The historical development of the Bill of Rights. People from England were tired of religious persecution and they fled to North America to settle in the colonies. The only problem was the king considered the colonies his possession, and any time he wanted to raise taxes, to raise money for himself, he was able to do so quite easily because there was no representation of the colonists in the parliament. Therefore, the colonists felt that they were taxed excessively and were generally felt that they were oppressed. Objectors to any of these policies were taken to England under the law of sedition, which means basically that you're violating the king's law. And if you were to criticize the king or say anything negative about the king, you were seditious in nature and you were taken to England for trial. And all of those persons that were taken to England for trial were found guilty and, of course, put to death or jailed. As time passed, more opposition was created by the colonies, and the king had to respond by sending in troops. Some of the things that they would do is if they suspected that you were a seditious or rabble-rouser or troublemaker, they would put a small group of soldiers in your home. And the soldiers would then take your home over, and you and your family would be sleeping in the barn. They could keep an eye on you, but in general, this was a way of oppressing those objectors. The objectors were also subjected to search and seizures without justification, looking for any sign of treason or sedition. As a result of the extreme actions of the king, the colonists banded together and adopted a resolution declaring their political independence from England. This document is the Declaration of Independence. Look out what you wish for, because sometimes you'll get it. After they won the Revolutionary War, members of the colonies were sent representatives to Philadelphia in 1786 to try to formulate an acceptable and workable government structure. They developed what is now known as the United States Constitution. One of the things that many people don't know is Benjamin Franklin actually penned an interesting draft of the Constitution before Jefferson, and in his it gave more rights to the citizens. One of the things that came to light in the writing of the Constitution was the fact that all the things that the king had done to the people, to the colonists, was reflected, or they attempted to protect those rights of the colonists for future connection with this government. U.S. Constitution, portions related to the administration of justice. Article 1, Section 6 basically says this: Congress is immune to arrest going to and from sessions, meaning that you could not arrest a congressperson on the way to make law. It protected them going to and from. After, yes. It was thought that it would prevent the government from stopping what the people would want to have done in sessions of Congress. Section 7, the president has 10 days to sign or veto a law, or it automatically becomes law. This way, if the president takes no action, it becomes law. It's a word of the people. Section 8 allows Congress to set up courts lower than the U.S. Supreme Court. And Section 9 is a writ of habeas corpus. We'll speak about habeas corpus a little later. Article 2, the executive branch. There's 3 branches in the Constitution that represent the government: judicial, legislative, and executive. The executive branch is supposed to carry out the laws of the legislative side. The police are included in this branch because they uphold the law. Section 2, President can grant pardons, appoint Supreme Court justices. And Section 3, the President has power to see that laws are faithfully executed. He does that with the help of federal agencies like the FBI, Department of Justice, and local police agencies. Article 3 establishes a judicial branch. Supreme Court is established. Now, one of the things you have to think about here is if I was to ask you the question, what of the three branches of government, which is the most powerful, the answer would actually be the judicial. More powerful than the president, more powerful than the legislators. The reason is they're members for life. And they're able to overturn those laws that might come out of the legislature that don't meet the guidelines of the Constitution. And they're also able to chastise law enforcement all the way up to the president in upholding laws and making sure that they guarantee citizens their rights. Article 4 establishes laws of reciprocity between states. Reciprocity, I give you, you give me. I scratch your back, you scratch mine. If a felon's convicted in Nevada, for instance, they're also considered a felon in California. If you're a California resident and you drive to Lake Tahoe, your driver's license and your vehicle registration is accepted by that state. Section 2, rules of extradition between states. Governors from one state who are asking to serve a warrant on someone in custody in another state must ask that governor permission. Section 4, each state has a constitution. Power of the government lies with the people, and it establishes a state legislative body. Article 5, Congress can amend the Constitution by two-thirds vote of both houses. This gives life to the Constitution, which means that as times change, the Constitution can change to meet those times. Article 6, rule of preemption. There's an order with which laws have more power than others, which can overturn others. The highest law in the land is a U.S. Constitution, followed by federal law, which is passed by Congress. After that, state constitutions, followed by state law, and at the bottom of the ladder, or the totem pole, would be local law passed by city councils or county boards of supervisors or town councils. Now, an example of this would be that the county of Alameda wanted to pass a law which allowed the issuance of hypodermic syringes. And this was at the very beginning of the AIDS epidemic, and they thought they were trying to do the right thing, and they were about to vote on passing this legislation, which would allow the giving away of hypodermic syringes. And the sheriff stood up and said, you know, I need to speak to you first before you do this. And what the sheriff said was, under the Business and Profession Code 4143, it stated that the distribution of syringes or possession of syringes was illegal. And he basically said that if you pass this ordinance, and these people, they had people there that were going to start to issue syringes as some symbolic gesture, and the news media was there. He said, we're going to have to start to make arrests because California state law does not allow people to possess syringes or distribute syringes except if they're licensed to do so or they have a prescription. And so what the sheriff was trying to explain to the county board of supervisors was that state law superseded the local law under the rule of preemption. Problems with the initial Constitution. So we have three separate branches of government: executive, legislative, and judicial. But various state representatives, remember we had 13 states at that time, felt that a vital weakness still remained in its structure. Now remember, the colonists have just suffered under a king, and they're wondering, who is this elected president? Could this person become as oppressive as the predecessor, as the king? Now at this time there were two basic political groups that were fighting for power. The first group was the Republicans. Now today we consider the Republicans to be a little bit more conservative, but back then the Republicans were the group that believed that the government should be of the people, for the people, by the people. The other group was the Federalists. The Federalists believe that the government should run the people. And so you had two different ideologies during this period that were fighting. So it was very hard to look at the civil rights issue at this time. The Federalists really wanted the government to have more power than the people. So there was some discourse, some conversation, some argument over these two ideologies. In 1789, the state sent representatives again to meet because they feared that the people would not be protected from oppression should the central government become too strong and powerful, so they met again. At this time, they drafted the Bill of Rights. Amendment 1, restriction on the powers of Congress. This was the first amendment. Had to do with no law respecting an establishment of religion. Free exercise of religion. Freedom of speech, the press, and although they weren't around then, it also meant radio and television. Remember, the Constitution is a live document. So nowadays, and also the internet now has become something covered under free speech. Right to peaceably assemble. If you don't feel that a law is fair or that a policy is fair, the people can assemble to complain. Right to petition government for redress of grievances, meaning that you could sue the government if they do you wrong. Although people may differ in opinion, everyone has the right to that opinion. In this example here, though, if this person is wrong, they could be held civilly liable and sued, but not put in jail. Again, freedom of the press to be extended now to the internet. I know there's a lot of controversy over porn sites and the fact that pornography is being considered artistic in nature, or some types are, and also the control of the internet, the balance between not allowing children access to negative material versus the access of adults. Amendment 2, right to bear arms. What this amendment was about, and I'll read it first: a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms should not be infringed. It basically meant that there could be a National Guard unit or a group that could protect those people in the state from attack. There is some various case law that has been around. Crinkshank, which basically talks about Congress will not interfere with each state's ability to regulate gun control. Or a sawed-off shotgun is an illegal weapon and is not necessary to defend yourself. Every state has the right to write their own gun control laws. In Texas, you can go get a permit, you can carry a gun exposed, you just can't carry it when you're drinking or use it illegally. Where in California, much more conservative, very few people have firearms permits, and if you're caught with a weapon, although it's a misdemeanor, you can be jailed, and the bail is quite high, I believe around $10,000. Amendment 3, billeting of soldiers. I spoke earlier about the fact that one way to control the people was to put soldiers in their house. Now, the rule was that no soldier shall in time of peace be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. So, if there is an enemy force coming up the bay near my home and the government wants to put a howitzer in my swimming pool, they will pay me to do that. They won't be there unless it's time of war, and they're going to give me some sort of payment for the use of my property. That's basically what that means. Amendment 4, this is a big one for law enforcement, having to do with searches and seizures and warrants. It says basically the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches. Now, you need to read carefully here. Unreasonable, meaning that if it's unreasonable, if it's reasonable, it's allowable. Doesn't say that the government can't search the people. And remember that the police are part of the government. It says that searches must be reasonable. And it says that no warrant shall be issued but upon probable cause, supported by an oath or affirmation, particularly describing the place to be searched and the persons or things to be seized. Meaning that if you have probable cause to believe that a crime has occurred or is about to occur, and there's evidence of that in a particular location, that you write up a document which describes the place that you want to search and what it is you're looking for and the things that you want to seize, and you submit that under oath, and you'll be granted a warrant for searching. So again, this covers search and seizure, covers warrants. Illegal seized evidence and its admissibility in court, covered under Mapp versus Ohio, 1961. And the exclusionary rule. What the exclusionary rule is a mandate that police follow the Fourth Amendment. If they don't follow the Fourth Amendment, no matter how material or relevant the evidence is, it can be excluded from court. Now, in the case of Dorley Mapp, there were some officers from Cleveland who were actually investigating a bombing which occurred at Don King, the illustrious fight promoter's home. He had shot a mafia kingpin who was trying to squeeze him for some money, and they came after him, bombed his house, and he basically called the cops to complain, and as a result, the police ended up at Dorley Mapp's home looking for the bomber. Now, Dorley was basically shown a piece of paper by the Cleveland police. It was basically nothing. She wasn't allowed to examine it. And she was handcuffed to a stair casing while they searched her house. They were supposedly looking for a person, although they looked in a small artist drawing kit, and they found what they believed to be pornographic drawings. That were pencil sketches of naked persons. And they seized them, and they charged her under their indecency law, and she got 7 years. As a result, the Supreme Court overturned that conviction and also established the exclusionary rule, saying basically that police had to follow the Fourth Amendment. They had to use search warrants if they were going to search. And this was a big change for law enforcement. Amendment 4, Criminal Proceedings, Condemnation of Property. No one could be held to answer for a capital crime or other infamous crime, meaning a felony, unless on the presentment of an indictment of a grand jury. Nowadays, we actually have a judge look to see that there's probable cause to hold somebody, and that's done within 2 days of arrest or under indictment of the grand jury, or the person's released. Except in the military forces. I'm not going to go in depth here, but if you're in the military, you sign a lot of your rights away, and you got to be in actual service in time of war or public danger. But the military is a whole different area of law, and we're not going to be covering that in depth in this course. It also talks about no double jeopardy, meaning that if you've been tried in a case and you've been found guilty or you've been found innocent, let's take it, you've been found guilty, and as a result of being found guilty, you're given probation. Another prosecutor tries to try you on the same case and get more time, that's not going to go. Another example is if O.J. Simpson jumped up right now and said, I'm guilty, here's all the evidence of my guilt on the case, I killed my wife, there's really nothing that we could do to him. except possibly perjury. But other than that, there's nothing we can really do with O.J. Simpson on his case. Matter of fact, I don't know that he testified. If he did not testify in his case, there's absolutely nothing can be done. There are a number of cases that are out there where suspects have testified. There's one I know of in the Midwest where a woman was tortured and sexually attacked by a individual, and he took pictures, and he hid those pictures in a heater vent at his home. And it wasn't until about a year and a half later, when the home was sold to pay for some of his legal fees, that the person changed the carpet, and as a result, the evidence was found, and they were not able to go after him for the murder because he had already been acquitted. However, he did testify in his trial, and they were able to get him for perjury. No self-incrimination. Now, you've probably heard of the Miranda Warning before. You have the right to remain silent. Anything you say can and will be used against you in the court of law. You have the right to have an attorney present with you. If you can't afford one, one will be presented without cost. Do you understand these rights as I've explained them to you? Do you wish to speak to me now? Well, it's pretty dry, but that's the basis of Miranda. Actually, you don't have to read that. As long as you advise somebody that they can have legal representation, it can be provided for free, and that what they say might be used in court, and ask that if they intelligently understand this and they want to talk to you, you've covered the basis. But it basically says that people can't be made to incriminate themselves. Also covered is that can't be deprived of life, liberty, or property without due process, meaning that you all have the right to a proper and fair trial, and that private property cannot be taken without just compensation. This is usually covered in eminent domain. If your city decides that they want to build a freeway in the middle of your home, they have to pay you. So again, double jeopardy. Once a verdict has been rendered, a defendant cannot be retried for the same offense. Right against self-incrimination. You can't be made to testify against yourself. As a matter of fact, it's basically thought that everyone is innocent until proven guilty in our country, and you do not have to take the stand to defend yourself. It's the prosecution that must prove that you did it. The Miranda Warning again. As long as someone understands it and intelligently waives it, they can speak to the police during questioning. One of the other things that you need to understand too is a person needs to be under arrest or similar to arrest, like in handcuffs, with a gun pointed at them when questions are being asked before Miranda applies. If I'm stopping somebody and I talk to them and they're not under arrest and they're willing to speak to me, they don't have to be Mirandized. The accusatory process. This is the process of accusation. In other words, where you're claiming that someone committed a crime. The first step, there's two ways that we get here. We get to arraignment and trial both ways, but if you look at the top portion of this diagram, you'll see PC to arrest, or probable cause to arrest. This is for the officer who doesn't have a warrant, who observes a person shooting another person. They see them pull the trigger, they see the person go down, they go up and they make the arrest. The next morning they're in court in a preliminary hearing in front of a judge, and they say what they saw. They basically say, Your Honor, I saw this person shoot the other person and I made the arrest. At that point, if the judge feels there's probable cause to hold the person for trial, they inform the district attorney to write an information. Now, an information is a document showing the actual charges in the case, count 1, count 2, count 3. From there, they go to the arraignment stage, and in arraignment, the person gets to respond basically saying whether or not they're guilty or innocent on the case, and if they say they're innocent, then the judge will schedule a trial. Now let's look at the bottom portion of this diagram. To the far left, you see grand jury hearing. In the county I'm from, Contra Costa, we have 19 grand jury members, and of those 19, you have to have I believe it's 11 that have to vote for indictment. And in a grand jury hearing, what happens is that the grand jury hears the testimony. Let's say that it's the same sort of case, and the officer would come in and testify about the case. They would show the gun. They would show ballistics showing the match between the victim and the gun that the officer took off the suspect. The grand jury votes for indictment, and once the indictment is voted on and approved, then a warrant is issued for the suspect's arrest. They're brought into arraignment, and we're back to that step of arraignment. They will basically plead guilty or innocent, or a nolo contendere. And this is another thing that let's go back over the pleas. You could be guilty, you could be innocent, you could be innocent by reason of insanity, or you can plead no contest or nolo contendere. No contest, nolo contendere basically allows you to say, I am not saying that I did it, but I'm not going to fight it. The reason that you do this is it doesn't lead to civil liability. In a civil court, they would have to prove that you were liable in the case. Why is this important? Well, let's go back to our friend O.J. Simpson. He was acquitted in criminal court, however, when he went to civil court, he lost his case. So you see there's two totally different things going on here. If O.J. would have pled guilty in the criminal trial, then that could have been used against him in the civil trial, and they would have said, basically, you've already said that you did it, so you're liable. However, they had to start a whole new trial, and they would have to start a whole new trial if he would have said no contest. So therefore, when you use the term no contest, you're basically saving yourself the civil liability. Amendment 6, mode of trial in criminal proceedings. Everyone has a right to speedy trial, usually 60 days from arraignment for in-custody cases. Right to a public trial, meaning that not everybody's going to get in, but there is the ability for the public to look at the trial to make sure that everything is up and that due process is followed. Also, that you have the right to an impartial jury, that you have challenges for cause, meaning that if there's a person who you feel is prejudiced towards you, you can exclude them. That there's preemptive challenges, meaning that you're just not sure about a juror and you don't want them on there. Or a change of venue, you don't feel that you can get a fair jury. Like in the Scott Peterson case, they moved him to a different county. Also, you deserve the right to be tried in the district where the crime was committed. That comes from looking at how the English would take the colonists and take them back to England, where they're already treated as second-class citizens, and try them there. They weren't tried with their own people serving as juries. Also, in the Sixth Amendment says that you to be informed of the nature and cause of your accusation, and that you have the right to confront witnesses that might testify against you, and that you have the right to force someone to testify in your favor. They call that compulsory process, or subpoena someone. That's what that means. So if Mrs. Jones saw you washing your car and the cops come to arrest you for a robbery, and you say, Mrs. Jones saw me wash my car at that time, and she doesn't like you, she doesn't want to testify, guess what? She can be forced to testify. And lastly, and probably one of the more important areas here, is that you have the right to assistance and counsel for the defense. Again, right to speedy trial. Trial by impartial jury. The right to confront witnesses and cross-examine them. Next, Amendment 7, trial by jury. It reads it in suits at common laws where the value in the controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by jury shall be otherwise re-examined in any court of the United States than according to the rules of common law. Meaning that no jury's decision can be re-examined by a federal appellate court unless the rules of appeal at common law, meaning that there was a violation of the constitutional right or that there was an error in court procedure. Also says that federal juries should be guaranteed cases involving over $20. Amendment 8, involuntary servitude. It basically says what used to happen was someone would be taken in custody, and while they were waiting for the trial to come up, they could work free manual labor for whoever the court put them with. The Eighth Amendment guarantees that there should be no excessive bail, nor excessive fines imposed, nor cruel or unusual punishments inflicted. In 1969, the state of Delaware abolished whipping as a punishment. And the reason they abolished it was because they couldn't decide on what sort of whip to use. They also could not decide how to give equal whipping to each person, meaning that if one of the correctional officers was 6'4", 250 pounds, that the whipping that person would produce would be different than a female officer who was 5'4", 130 pounds. Which one would you want to be whipped by? But that's why that was overturned. They couldn't come up with a way of making it the same for each person. Again, quick review: right to bail, no cruel and unusual punishments. Amendment 9, certain rights not denied to the people. What this meant was, okay, we have a new constitution and we have certain rights that we're laying out here, but we don't want to deny or disparage other rights that are already been retained by the people. So these are in addition to whatever rights people already had before the writing of the Bill of Rights. Amendment 10, states' rights. The powers not delegated to the United States by the Constitution, no prohibited to the states, are reserved to the states respectively or to the people. This gave the power of the states to guard against violations that they felt were against public morals, to develop their own public safety and public health policy. And the thought here is that, again, a good topic is gun control. In Texas, more citizens believe that they should be able to have weapons available to them. And in California, there's a very, very big anti-gun movement where they're trying to eliminate weapons. This also has to do with the severity of how certain crimes are charged. In the South, up to around 5 years ago, there was a death penalty placed on rape convictions. And we're talking about Louisiana, Mississippi, Georgia, where in California there are prison sentences, but they don't equate to a death penalty. And the Supreme Court basically said that those southern states had to come in law, and they could give a life imprisonment, but they could not take a person's life for only a rape without a death associated. In 1868, the 14th Amendment was adopted, so this is some time later. And basically what this did was it said that all persons who are born or naturalized in the United States are subject to the jurisdiction thereof and are citizens of the United States and of the state where they reside. Said that no state shall make or enforce any law that shall abridge the privileges or immunities of citizens or the United States, nor shall any state deprive any person of life, liberty, or property without due process, nor deny to any person within its jurisdiction the equal protection of the laws. This was something that was used heavily in the civil rights movement, saying that everyone had the right to educational and work opportunities to live where they wanted to live. And it basically, if you look in 1868, this did away with slavery and opened the doors to civil rights for peoples of color. What's the definition of due process of law? It means that the accused shall have their day in court with the right to an appeal or conviction. Fair and legal methods will be used when persons are charged with crimes, and the law will be applied equally to all citizens. Protection from state government also. Sources of law. We have the U.S. Constitution. We have state constitutions. We have federal legislature, which are federal laws. State legislature, state laws. Counties, cities, and towns. This is very close to our rules of preemption here. But it adds decisions of appellate courts where judges are interpreting the Constitution and setting new case law. Historically, it comes from English common law, religion and morality laws, social control through customs and norms, and executive agency rules. Making a new law. There's three processes that are used by California, and I'm going to speak directly about California, by which laws are made or revised. The first is the making of new laws. The second is the repealing of old laws. And the third is the amending of the state constitution. Two legal approaches. First is through the state legislature, and the second is through a referendum or initiative. Through state legislature, you have the Assembly and the Senate, and it can start in either one. How laws are made. A legislator sponsors a bill. They introduce the bill to the House. And it's reviewed in special committee. And at that point, the public gets to speak about it, to voice whether they think it's a good or a bad law. Then the bill is amended, it's revised after the public hearings. And it's read on the floor and voted on. Now, if the bill passes, it goes to the other house. And the procedure is repeated and a final bill is produced. It goes to the governor, who has 10 days to decide to veto it, meaning that deny it, or to accept it, or it becomes law automatically. The other way that a law, an idea becomes a law is the public proposes a new law. An example could be the medical marijuana initiative in California. They have to collect signatures from 5% of the number of voters who voted in the last election for governor. Again, 5% of the number of voters who voted in the last election for governor. It's placed on the ballot, and citizens vote on it. And they can repeal the law, they can change it, or they can institute it. going to give you an assignment now, and that's to go to www.assembly.cal.gov. And what you're going to do there is you're going to develop a new law using what's called the Kid Stuff game. You'll see it right there on the website. And in that website, you need to play the game, write your own law up, and you're going to go to our discussion board, and you're going to be able to talk about or answer some questions about the law that you devised and why you did it, why you think it's important. Key terms in this section: development of the Bill of Rights. Why was it important? And which ones really are related to criminal justice? Reciprocity between states. What does reciprocity mean? The rule of preemption. Should know that list by heart. Precedents. And when we talk about precedents, I talked about the fact that sources of law, you have judges that interpret the Constitution and make case law, and those hold the precedence over future decisions that could be made. The amendments you need to review would be 1, 4, 5, 6, 7, 8, 9, 10, and 14. You should be able to define due process. You should be able to list sources of law. And you should be able to talk about how laws are made through state legislature or through referendum or initiative. This is the end of Lecture 2.